Today, we will review the Subrogation Agreement, which, effective October 18, 2020, is one of the General Land Office's required documents for voluntary buyout or acquisition programs. A hyperlink to the Subrogation Agreement can be found on the Texas General Land Office website at recovery.texas.gov. To locate the document, go to the local buyout and acquisition program page, which is linked below in the description section of this video. Scroll down to the left side checklist section and click on the Subrogation Agreement link. Once you click on the link, your computer will download the fillable document. Please note, you will need Microsoft Word to view and edit the document. All applicants, co-applicants, and anyone with interest in the property are required to complete a subrogation agreement. Subrecipients must ensure that CDBG funds are not duplicative of other assistance received for the same purpose or activity. Prior to eligibility, applicants will need to complete the Duplication of Benefits calculation form to ensure that there is no duplication of benefit in the assistance received. However, there still exists the possibility that an applicant will be eligible for or received funds from another source for the same purpose or activity after the duplication of benefits form has been calculated. Therefore, the subrogation agreement is important because it ensures that the program, not the applicant, will be the recipient of any additional funding for the same purpose or activity up to the amount that was awarded under the CDBG program. This ensures that no duplication of benefits may occur in the future. In addition, it gives the subrecipient and/or the state the right to pursue those funds for the program. For this video, we'll use an example of a fictional applicant and location to explain how to complete the subrogation agreement. Section 1 of the form is for the subrecipient to input the program information. First, the subrecipient should input the funding source related to the program. For example, it could be Hurricane Harvey, 2016 floods, mitigation, etc. For our example, the program is the General Land Office Hurricane Harvey Local Buyout and Acquisition Program, so the funding source is Hurricane Harvey. Next, the subrecipient will input the federal award number. This is the award number that was used on the Federal Assistance SF-424 form. If the number cannot be located on the SF-424, it is also located on the first page of the GLO contract. For this example, we have used B17DM480001 for Hurricane Harvey. Next, the subrecipient will input the name and title of their authorized representative. The authorized representative is the person legally empowered to contractually bind the subrecipient to the terms in the document. The authorized representative must be one of the two individuals listed on the authorized signatories designation form for signatories for contractual documents. And the subrecipient will insert the subrecipient address. On the next line, the subrecipient will input their contract number with the GLO. Finally, the subrecipient will input the date that the contract was executed. The executed date is the date that the last party signed the GLO contract. Once the subrecipient has completed the program information, Section 2 is for the applicant to input their information. On the first row, the applicant and co-applicant will input their names. For our example, the applicant is Robert Alejandro Smith Rodriguez and his wife Susan Shirley Rodriguez, who is the co-applicant. The applicant will then input the address of the property to be bought out or acquired, and the city, state, and zip code of the address. The final row in this section is for the property's legal description. The property's legal description is a description of real property by a government survey, a meets and bounds survey, or by lot numbers of a recorded plot. The description allows a parcel of land to be located and identified based on what is written. The legal description is kept with the deed and filed with the county clerk or tax assessor. The legal description can be found on the tax assessor's website or the title commitment. The next section of the document describes the Subrogation Agreement and lists all of the legally binding agreements that the applicant will be held to upon signing the Subrogation Agreement form and participating in the program. First, the agreement states, "This Subrogation Agreement is hereby entered into as of the date listed above by and between the applicant and co-applicants, if applicable, and the authorized representative of the subrecipient or state for the purpose of carrying out eligible activities under the Texas General Land Office Community Development and Revitalization Program." This statement affirms that the agreement is between the applicant and all the people with interest in the property and the subrecipient and/or state for the local buyout or acquisition program, which is a part of the General Land Office Community Development and Revitalization Program. Next, the agreement states, "In consideration of the applicant's receipt of GLO CDR funds administered through the program, applicant hereby assigns to the program all of applicant's future rights to reimbursement, including, but not limited to, any reimbursement or relief program assistance related to or administered by the Federal Emergency Management Agency, the Small Business Administration, or any other source. Applicant also hereby assigns to the program all of applicant's future rights to all payments received under any policy of casualty or property damage insurance, including, but not limited to, homeowners insurance, wind, flood, or any other type of casualty or property damage insurance paid as a result of physical damage to the structure, as defined within the agreement. That was the basis of calculation of applicant's award to the extent that grant or loan proceeds were paid to the applicant under the program. Applicant hereby assigns rights as they relate to the specific structure defined within this agreement and with respect to grants and/or loans described within the applicant's correlating application for assistance under the program. Applicant acknowledges that this assignment of rights only pertains to assistance calculated using physical damage caused to the structure by specific correlating disaster event. This includes any insurance and program proceeds received for damage to the structure caused by any subsequent event that occurred prior to the commencement of repair or reconstruction of the structure utilizing program funds. To summarize, this language in the document indicates that the General Land Office Community Development and Revitalization Program has all future rights to any assistance received for the same purpose or activity as that which will be received in the local buyout and acquisition program. Examples of additional assistance that may be received include FEMA, SBA, insurance proceeds, and more. Next, the agreement states, applicant agrees to assist and cooperate with the program should the program elect to pursue any of the claims applicant has against the insurers for reimbursement under any such policies. Applicant's assistance and cooperation shall include, but not be limited to, allowing suit to be brought on behalf of the applicant and in the applicant's name, participation in depositions, provision documents, producing records and/or other evidence, testifying at trial, or any other form of assistance and cooperation reasonably requested by the program. Applicant agrees, if requested by the program, to execute any additional documents and/or instruments that may further and better assign to the program the rights listed above. Such further documentation shall only further or better assign to the program rights to the extent of the following proceeds paid to the applicant either under the program, homeowners policies, or programs administered by the Federal Emergency Management Agency, the Small Business Administration, or any other source. Applicant agrees to take or cause to be taken all actions and to do or cause to be done all things requested by the program to consummate and make effective the provisions of this agreement. Applicant explicitly agrees to permit the program to request, on applicant's behalf, to request any pertinent information related to this agreement from any company with which applicant held any relevant insurance policy, or any of the following agencies through which applicant applied or received funding: the Federal Emergency Management Agency, the Small Business Administration, or any other source. Applicant understands that requested information includes any non-public or confidential information needed by the program to monitor and enforce its interests in the rights assigned under this agreement. Applicant hereby gives consent to any and all above listed sources of information to release said requested information to the program upon request. This language indicates that although the applicant and all the parties of interest on the subrogation agreement no longer have rights to future assistance, they must still continue to pursue claims and assistance that may be owed to the applicant for the program. In addition, the program has the right to pursue that assistance in lieu of the applicant, including requesting non-public information and documentation on the applicant's behalf. For example, if an applicant previously made a claim for insurance proceeds, but still is in litigation to receive those proceeds, the program may represent the applicant to fight for those proceeds, and if any additional information or documentation is needed, the program may request that information from the insurance provider. Also, the applicant must work with the program to ensure they get all of the documentation they need in order to receive the insurance proceeds. Next, the agreement states, applicant agrees that any future receipt of payment from any sources outlined in the agreement shall promptly be forwarded to the program. The program shall maintain the right to recover these payments until they total the amount equal to funding provided by any of the sources presented in this agreement. Once the program has recovered an amount equal to assistance paid to the applicant from any of the sources presented in this agreement shall no longer be legally effective. The previous statement indicates that the applicant and all interested parties are responsible for forwarding any assistance received for the same purpose or activity to the program until the amount of money paid equals the assistance provided by the CDBG-DR program. Next, the applicant acknowledges that this agreement does not impair applicant's mortgage lender's rights under any deed of trust or mortgage or the structure. Then, the agreement states, in any proceeding to enforce this agreement, the program shall be entitled to recover all costs of enforcement, including actual attorney's fees. This means that in the event that the applicant or other interested parties do not comply with the agreement, the program may enforce the agreement, and any attorney fees or other costs included with enforcing the agreement may be owed by the applicant. Section 3 is the final section of the form. In this section, the applicant, co-applicant, and authorized representative of the subrecipient will print their name, sign, and date the signature section of the form. With these signatures, the applicants and subrecipient are certifying the above information and requirements. We hope you enjoyed this training on the Subrogation Agreement. If there are any additional questions during the completion of the form, subrecipients should reach out to their General Land Office Grant Manager. Additional videos covering the other required local buyout and acquisition forms are, or soon will be, available at the same location you are viewing this one.